Good morning. My name is Malcolm Newkirk. Welcome to Threaten's third coffee break briefing of this year. Today I'm going to be talking about pubs, clubs and restaurants, leisure businesses. Now the date for next month's coffee break briefing, if you'd like to make a note of it in your diary now, is Monday the 9th of May. I hope you'll be able to join me for that. And I've got another date for your diary. It's that of our first annual Insolvency conference. It will be on Friday the 10th of June at a splendid location on Bournemouth Clifftop overlooking the sea. I hope you will have received an invitation by now. We've had quite a few bookings. We're not yet having to say that spaces are limited, but I would encourage you to book soon if you intend to. This morning, I'm going to be talking about leisure businesses, by which I mean pubs, restaurants, clubs, and the like. There are some immediate issues that are facing businesses of this sort. One of them is VAT. There was a big VAT concession early on in the pandemic when the rate of VAT was dropped to 5%. It went up to 12.5% in the autumn, and as from the start of this month, it is back up to the full 20%. The next issue is that winding up petitions are back. This doesn't apply only to the leisure sector, of course. It applies to all businesses. Temporarily, the debt threshold for bringing a winding up petition had been increased from £750 up to £10,000, and as from the 1st of April it's now back down to £10,000 again. There had been interim provisions that said that anybody bringing a winding up petition had first to offer a 21-day breathing space in effect to the debtor. That's now no longer needed. Of course, there's still the 21-day period for statutory demands to mature, so that's probably not going to make a huge difference, but it's one major formality that's been removed from presenting a winding up petition. And if it's the landlord who is intending to bring a winding up petition, then for the next 6 months, if the rent that the landlord is trying to cover is protected rent, and I'll say a bit more about that, or if it includes protected rent, then the landlord must first offer arbitration to the tenant to try and agree terms for payment before presenting a winding up petition. But generally speaking, as far as winding up petitions, the moratorium has largely lifted. And landlords haven't just got the right back to bring winding up petitions, but they've got all of their other pre-existing rights back. There was a moratorium on all of these things before. They could not sue their tenant for unpaid rent. They could not forfeit commercial leases, either through court procedures or by peaceable re-entry. They couldn't send in the bailiffs to seize their tenants' goods using the commercial rent arrears recovery procedure. Couldn't even call on a rent deposit if they had one, and they wouldn't be able to present a winding up petition. All of those moratoria have now ended as well, again with the continuing protection for tenants from claims for protected rent, where landlords do have to go through an arbitration procedure first. And then there's the economy generally, and I think many forecasters are suggesting that it's likely that consumers will have less discretionary spending, less money to spend at the weekend or on a Friday night on going to a restaurant or going to the pub or whatever. And today's headlines were suggesting that the price of a pint of milk is about to increase by 50%. As just another part of this overall squeeze on people's spending powers. And of course, COVID, numbers are still on the increase. It is affecting the availability of staff. People who have caught it are likely to want to stay away from going out to pubs and restaurants and so on. And so that is itself also having a depressing effect on the market. So I think the summary of all of this is that things are not going to be easy for businesses in this sector over the coming months, and possibly a bit longer than that. So on to the technical aspects, the legal points that I want to talk about. And there are 4 main headings I've got here. I want to start by talking about licensing, which is of great importance to leisure businesses and does contain issues that you need to think about when there is to be a formal insolvency of a business of this sort. I will say a bit more about landlords and the rights that they have got. I want to say a few words about law of Property Act Receiverships, and I want to finish then by talking about what I'm calling here low-hanging fruit, which is really just a few words about why it is that company directors in this sector are perhaps particularly vulnerable to disqualification actions, and is something that you probably ought to be covering in early conversations with the directors of businesses of this sort. So let's look at licensing, by which we mean licensing under the Licensing Act 2003. And there are basically 3 broad categories of businesses that have to be licensed under this legislation. First broad category is if you're selling alcohol, whether you're selling it for off-license sales or on sales for consumption on the premises or away. If you're selling alcohol to the public, selling booze retail, then you need a license. If you're putting on entertainment for the public, you need a license. And entertainment here means music, dancing, plays and films. Some interesting exceptions to that. Morris dancing is specifically excluded. If the only entertainment that you're providing in your business is Morris dancing, you don't need a license for that. Similarly, licensed sex businesses have their own legislation under which they are themselves licensed. They don't need to have a second license for the alcohol that they are selling or any other entertainment they put on. There's no need for double licensing of those businesses. And moving vehicles do not need to be licensed. So airliners, for example, do not need to carry a license to play soothing music to you as you trundle down towards the end of the runway. And the third type of business that needs to be licensed is late night refreshments. So a business that's selling hot food or drinks late at night, which means after 11 o'clock at night and before 5 o'clock the following morning. And again, that applies to on and off sales, whether the food is being eaten in a cafe or whether it's a kebab van where the food is being taken away. They all need a license under this legislation. And there are 2 types of licenses that are relevant to businesses of this sort. The first one is the premises license, and as the name suggests, that authorizes the premises for the particular type of business. And the premises license should be in the name of the person carrying on the business. That can very often be the company that's operating the business. So the premises license might actually be in the name of the company that you're dealing with. It's not always. Sometimes it can be in the name of another. For example, there may be a group structure with more than one business involved in running the business, in which case you might find that the license is held in the name of a separate company. And there are some licensed premises where the license is held in the name of the landlord rather than the tenant that's actually operating the business. So it's something that you'll need to do. One of the first questions you'll need to ask when you first become involved with the business is, whose name is the license held in? The second license that the business needs is a personal license. And the personal license is it's like a qualification to be a pub landlord. You only need a personal license if you're selling alcohol. If you're involved in the other activities, for example, late night refreshments, and you're not selling alcohol, you don't need a personal license. But if you're selling alcohol in part of the business, then you do need to have a personal license. The personal license has to be held by the individual who is the designated premises supervisor, and that individual has to be named in the premises license as the designated premises supervisor. At the bottom of this slide, I say in insolvency, the designated premises supervisor is unlikely to be a problem. I mean, they may be a problem as an employee, but they're likely to be an employee of the business. They may be a director, they may be another senior employee, the manager of the particular premises, whoever they are. If you lose them, then you simply bring in somebody else who has a personal license to be designated premises supervisor to make sure that the business stays open. If the business is not being open in insolvency, if it's not continuing to trade, then if you've lost the designated premises supervisor, that's not too much of a problem while the business is closed. The premises license is potentially a problem that can directly involve you. And that's because there are a number of events that trigger the immediate lapse of the premises license. And these include the death of the holder of the premises license if they're an individual, or their mental impairment, or if it's a company that holds the premises license and it's dissolved, that will cause the license to lapse. If the premises license is for a club and the club ceases to be a recognised club, again, the license will lapse. And again, if it's in an individual's name and that person loses the right to work in the UK, they lose the premises license immediately at that point. The one that is going to affect you, the one that's most relevant here, is the effect of insolvency, because all of the Insolvency Act statutory insolvency procedures cause the premises license to lapse immediately upon your appointment. And here's the list of the types of insolvency procedure that do trigger the loss of the license. Voluntary arrangements, individual voluntary arrangements, partnership voluntary arrangements, company voluntary arrangements, and in Scotland, protected trust deed all cause the loss of the license. Bankruptcy causes the loss of the license as well. Administration, administrative receivership, and liquidation all cause the license to lapse as well. And it is the start of each of those procedures that brings the license to an end. Now, although this may not have an immediate effect on you if you're not trading the business, nevertheless it will affect the value of the business, because if the license is lost, it can be expensive and time consuming to get it back again. You would need to start with a new application, which does take some time to work its way through. It can't be accelerated. There are notices that have to be given to various interested parties. So losing the license is normally undesirable, and although it does lapse immediately you are appointed, you can reinstate it if you act quickly. You have 28 days to reinstate the license, and there are 3 options that you've got to do so. The first of those is to get an interim authority notice, which is effective as if the license had been transferred into your name temporarily for 3 months. Your second option would be to transfer the license into your own name. And the third option would be to transfer the license to another person. Which of those is the right thing to do will depend on the circumstances of the business, and you ought to have a strategy for dealing with that as soon as you are appointed to the company. It's going to be particularly important to have the strategy worked out in advance if you are intending to trade the business in administration, for example, because the license having lapsed immediately on your appointment means that you will not be able to open the business until you have got the license transferred or an interim authority notice in place. The interim authority notice is something that you are entitled to simply by virtue of having been appointed as office holder to a license holder. And an interim authority notice does take effect as soon as you deliver the forms to the local authority. So if you've got a strategy in place to apply for an interim authority notice immediately on an appointment, you may find that you are without a license only for a matter of a few minutes or a couple of hours at most. If you want to transfer the license to yourself, that's not usually a problem either, as local authorities, as a matter of practice, do treat the administrator or liquidator or other office holder as entitled to have the premises license transferred into your name. Looking at the difference between a transfer of the license and an interim authority notice, the interim authority notice reinstates the license immediately, but it's only a temporary arrangement. It lasts for 3 months. It does effectively make you the license holder, and the police and the Home Office have got very limited rights to object to an interim authority license. So it offers certainty, but it's only a temporary solution. Transfer of the license also reinstates the license, so although it has lapsed, as soon as it is transferred, it is effectively unlapsed, it is revived. And the transfer of the license is essentially permanent. Once it's been transferred, you can continue to hold the license for as long as you need to, and you've got the right to transfer it again. Just as an interim authority notice has immediate effect as soon as you apply for it, you're treated as having the license back. So if you apply to transfer the license, that takes immediate effect as soon as the forms are lodged. But the local authority, the police and the Home Office do all have rights to object to the transfer of the license. So that's a quick run through licensing. I'm going to talk briefly now about landlords. And I mentioned earlier that the statutory moratoria that have restricted landlords' rights have now all come to an end. And if the landlord is looking to recover arrears of protected rents, then during the next 6 months, landlords first have to offer arbitration to their tenant before taking enforcement action. Now, remember that it's only protected rent that remains within any sort of statutory moratorium. If a landlord is trying to recover other rent arrears from their tenant, then it's back to how it was pre-COVID, and landlords have got all of their rights back again. Protected rent is unpaid rent that is attributable to the time that the business was closed by COVID-19 regulations. And that period will depend upon what sort of business it was and whereabouts in the country it is, because the closure periods were slightly different in Wales to what they were in England. So this page shows hospitality and nightclubs which were closed from the 21st of March 2020 through to the 18th of July 2021. and hotels and bed and breakfasts were closed for a similar period. Again, those closure periods were different in Wales. And other leisure businesses are on this second slide, with different periods for indoor leisure businesses, which in this context essentially means gyms, for outdoor sports and leisure, for theatres and cinemas, and for stadiums. Now, as I've said, it is only protected rent that is within that statutory moratorium, which is the unpaid rent attributable to the time that the business was closed by COVID regulations. And if the tenant owes rent from before that period or after that period, then that won't be protected rent, and the landlord's rights as they were pre-COVID have been reinstated now to collect that. If the landlord is owed protected rent, then they've really got two options. Either they can wait until September this year, when the final restrictions are due to be lifted, although of course it's possible that they may be extended for a longer period than that, depending upon circumstances at the time. That's their first option. Their second option is to start the arbitration procedure, which is a prerequisite of them bringing legal action to recover rent arrears where the rent is protected. And to start the arbitration, they have to make a formal offer in good faith, which should be their best offer of a concession on the protected rent. Now, on this slide, I'm assuming it's the landlord who's going to start the arbitration procedure, but it could be the tenant who does so. Either party has the right to do so. So the landlord, having made their best faith, sorry, their good faith best offer to the tenant, the way that can work out is either the tenant may accept the concession, or there may be negotiations and the landlord may agree something that's slightly more favourable to the tenant, or a lot more favourable to the tenant as a concession. Or the parties may not agree, in which case an arbitrator will then be appointed, and the arbitrator, I spoke about this last month, if you want to know more detail about this, but the arbitration is a flip-flop arbitration, which means that the arbitrator doesn't have the discretion of sawing it in half. The arbitrator can either accept the landlord's proposals and impose them on the tenant, or they can accept the tenant's proposals and impose them on the landlord. Or the arbitrator can decide on the evidence that they think that the tenant's business is not viable, in which case the landlord is then free to enforce their legal remedies. The landlord can then take steps to bring the tenancy to an end, or take legal action against the tenant, whatever they want. So that's a quick look at landlords and their rights. I'm going to look very briefly at Law of Property Act Receiverships. And the context behind these is that you'll be looking here at a business that owns the freehold of its own premises. And almost certainly they will have a mortgage in place to fund the purchase of that property. And the lender will have, through that legal mortgage, the statutory right to appoint a Law of Property Act receiver. Now, a pure Law of Property Act receiver, one who has only their statutory powers, will have extremely limited powers. The statutory powers given to a Law of Property Act receiver are basically to collect rent, and that's about it. There's very little beyond that. And where you're looking at a business that owns the freehold of its own business and trades from that freehold, there won't be any rent to collect. There's no tenant there. So a pure Law of Property Act receiver in those circumstances really isn't much use. And for that reason, most commercial property mortgages do give extended powers to receivers when they are appointed. And those extended powers invariably include a power of sale, a power to take possession of the property, and a power to manage the property. So most modern commercial mortgages do give the lender the power to appoint a receiver who can take control of the property. Now, it's a bit more complicated than that, because all that a receiver is entitled to take possession of is the property that is pledged to the bank, that's mortgaged to the bank. And if the mortgage contains too many charges, then the appointment of a receiver will be, as a matter of law, the appointment of an administrative receiver, which in almost every case now is not permitted, and so the appointment of the receiver will be invalid. So the art is to draft the mortgage deed so that it contains enough charges and powers for a receiver who is appointed to be able to do what they need to do, but not so much that a receiver who is appointed will be invalidly appointed because they're an administrative receiver. LPA receiverships are probably more useful, more common when dealing with unincorporated businesses, sole traders and traditional partnerships, because businesses of those sorts can't create floating charges and therefore cannot give their lenders debentures, and so the lenders to those businesses can't hold a qualifying floating charge and so can't appoint an administrator. So the closest they can get to appointing an administrator would be to appoint a law of Property Act receiver with extended powers. But the powers of that receiver will be quite limited because they won't extend to the assets that would normally be caught by a floating charge. And so there's likely to be things like the fixtures and fittings, the furnishings, and the stock in trade are all going to be outside the scope of the receivership. You can still appoint receivers who can trade businesses like that, but it does take quite a deal of care and planning to get it right. That's Law of Property Act Receiverships in brief, and I'm now going to be talking about what I'm calling here low-hanging fruit, Company Directors Disqualification Act. And just the context behind this is that company director disqualifications, the annual rate of those is about 1,200 a year. About 100 directors a month get disqualified following insolvency. And it seems that perhaps a disproportionately high percentage of those are directors of restaurants, pubs, businesses of that sort. And I don't think that's because they are directors who are any less qualified or diligent than those of other businesses. I think that's a consequence of the nature of the business. And I'll give you the example here of a pub or a restaurant with tight cash flow, trading from hand to mouth at the moment. Every week they're not quite sure whether they're going to be able to open for business or not, but they're desperately hoping that they can trade out of this. Their problem is that they can't buy the food that they need on credit, because you can't buy food on credit, and similarly you can't buy alcohol on credit either. And the staff, not unreasonably, expect to be paid every week, as they always are. And there's also a landlord or a bank who expects to be paid, and the owner of the business is very anxious that if they don't pay the funder of the premises, that they will foreclose or forfeit, as the case may be. So it may well be that when cash is tight and the owner of the restaurant can't pay everybody who needs to be paid that month, the person who doesn't get paid is HMRC for VAT and the PAYE, because the owner of the business can not pay them and still open for business, and all of their other creditors would close them down if they weren't paid. And if the business now fails, then from the disqualification unit's point of view, they can see that other creditors have been preferred, that trading has been at the expense of the Crown, and that of itself is enough to get a disqualification order against the director. So if this case is picked up by the disqualification unit to be followed, then it's an easy win for them. They know that they're likely to get a disqualification order on it. Hence, if you are advising the owner of a business of this sort, you perhaps need to warn them that they are perhaps more at risk of disqualification than they would be if they were in a different line of business, just because they've got fewer options. So that's covered the 4 points I wanted to talk about: licensing, landlords, LPA receivership, and low-hanging fruit for disqualifications. If you've got any questions, please do ask them. This is where I will now have a quick check and just see if I've received any questions. I don't seem to have at the moment. So just to remind you then that the next coffee break briefing is on Monday the 9th of May, again at 10:30 in the morning for half an hour. I will confirm what the topic is, and please also remember that we've got our annual conference coming up on the 9th of June, and I hope to see as many as possible of you at that in person. So thank you all very much, and goodbye.